Next case in our call this morning is agenda number 12, case number 102372, People of the State of Illinois, Appellee versus Joanne McCowan, Appellant.
Good morning, Your Honors, Mr. Chief Justice, and may it please the Court. My name is Don Ramsell. I represent Joanne McCowan. I'll be conducting the main argument for Joanne McCowan, and my co-counsel, Ed Maloney, will be supplying the rebuttal. The basic question before Your Honors today is whether or not the police-administered HGN test is admissible in court to prove the conclusion that a person is alcohol impaired. The short answer is no. Does
that mean what we're about here is determining whether or not the trial court made an error at the Fry hearing?
Well, frankly, the trial court, after the remand, has made certain rulings which we disagree with. To address those specifically, the trial court really never answered the question whether the test is admissible to prove the conclusion that a person is alcohol impaired. Rather, Judge Brandt specifically held that it's admissible for the possibility that a person consumed alcohol and that they might be under the influence, which is far below the dictate of this court, which was whether it in fact proves impairment.
Wasn't the question this court sent back was for a Fry hearing to determine whether it is scientific and whether it's accepted, generally accepted in the field of science, and whether the methodology is accepted in that field?
Yes. It was a very large question. I actually looked through the court's original decision here in McCown 1, if I may refer to it as such. And the charge that was sent back to the trial court for the purpose of the Fry hearing was not to determine its admissibility for the possibility of impairment, but its admissibility for the proof or conclusion of impairment. I simply bring that out because I believe that what the trial court's rulings were fell short of the charge for which it received. Now,
wasn't the charge to conduct a Fry hearing?
It did do so. But the question I thought that was put before the court there was to answer ultimately after the Fry hearing the question of whether it proves impairment. And what we received as an answer, to summarize, is that it proves the possibility of impairment, much like the smell of alcohol may.
This is very important that we're answering the right question. If it was to get a Fry hearing, it was to determine whether or not the HGN process was generally accepted within the community in which it was used.
Yes, and there were findings of fact by Judge Brandt on that issue as well. He did find that...
The judge found general acceptance. Would that conclude what the trial judge was given to do? In other words, conduct a Fry hearing and determine whether or not there was general acceptance?
Yes, he did find that it was generally acceptable to prove the possibility of consumption of alcohol and generally acceptable to prove that somebody might be under the influence of alcohol. I emphasize that because Ms. McCown was convicted allegedly based on proof beyond a reasonable doubt, and the actual trial itself, the test was used not for the possibility of impairment, but for proof of actual impairment.
On that issue, there was further evidence other than the evidence of the HGN test, wasn't there?
There was evidence of a double zero, if you will, alcohol test, and there was no other field sobriety tests. There was very little evidence, and this court itself found that the HGN test did form a major portion or basis for the finding of guilty for its admission as proof of actual impairment. It was not introduced for the purpose of possible impairment or possible consumption of alcohol.
Mr. Ramsell, and you indicated the trial court here did say that the HGN testing satisfies the Fry standard in Illinois. And isn't it also true that most states that have addressed this issue, HGN, either under Fry or Daubert, have likewise found? Is that a fair statement?
As a poll, I would agree with Your Honor. However, this is the most extensive and, frankly, the only hearing I would submit where both sides really were able to introduce the full plethora of evidence. Many of these other hearings were one-sided.
Back to Chief Justice Fitzgerald's question on how important the question is. I think, one of the things we're getting to, why wouldn't it relate to admissibility versus weight of the evidence, right? Whether or not this should be admissible, you can argue weight in any specific case, right?
Well, Judge Brandt, to be candid, was wrong. That's what we feel. There are many reasons for that. First off, we go back to his finding, which was that he found that the test was admissible in the field of optometry, and he resorts to a resolution that was performed or passed by voice vote or otherwise without debate or research at an American Optometric Association convention.